Good morning. Welcome to your final exam review. We will cover all the chapters. Technically, we didn't in class go into chapter 14, which was creating a plan, but really we've kind of been doing that throughout. So all those different pieces, graduate students' project was creating a comprehensive estate plan for yourself and your hypothetical client. So you pieced all these things together. So exam 4 is going to cover an additional chapter and a half that we hadn't got to for exam 3. So we finished chapter 12. The first part of chapter 12 was on exam 3. And then we went into chapter 13 with that generation skipping transfer tax. The format of the exam will be 50 multiple choice questions. Some of those will be calculations just like exam 3, and they'll be worth 2 points apiece. So I'll set them up in Blackboard just like exam 3, but the rigor, the difficulty level of the questions will be upped. Open book, open note, just like last time. So I will skip ahead to the newer material. Then we can come back and talk about whatever you would like, or I'll just start at the beginning. Let's start with the divorce recap. So that was where we had our Kahoot, and we talked about how in Alabama, the person that calls it off, unless there's some sort of fault and you want to take it to court, the person that called off the engagement is the one that either keeps or is the one that does not get the ring. So if you were given a ring and then you call it off, in Alabama, you would be giving that back. It would be a conditional gift where you didn't fulfill the expectation of the marriage. If you were the one that gave the ring and then called it off, you can't demand the ring back because you're the one that chose to not follow through with whatever that condition was. Some states will look at the engagement ring as a conditional gift subject to you actually marrying, but courts would also look at fault. So if somebody cheated, if somebody engaged in one of those things that if you were married, we could have a fault divorce. So proving some sort of wrongdoing, the most common being infidelity. The no fault divorce is just, we've got differences. We don't want to follow through, nobody's mad at anybody, but we've decided that we do not want to get married. Or if we are married, we've decided that it's not working out and we want a divorce. The judge is going to look at fault when determining the division of assets. If you have a prenuptial agreement, you can build some things in there where it doesn't matter if there was fault or whatever, or you could say, hey, I'm going to penalize you. If you cheat on me, this is what I get. If it's just we decided we don't want to be married anymore, maybe we can have a different division. So you can build that all into a prenuptial agreement. A prenuptial agreement is valid if we have entered into it voluntarily, we've disclosed everything. So think of a net worth statement, all your assets, all your liabilities, and we have valued them fairly. And that value, especially with the small business, is one of the things that gets challenged most often when there is a divorce. So full disclosure of everything, we entered into this voluntarily, and it's fair. It could be we both keep everything, doesn't matter if we're in a community property state, we're saying that all our assets are separate. You actually have to have a spouse sign off on pension plans if you put somebody else as a beneficiary of your pension plan. So with a defined benefit plan, you can set those up where maybe it's 75% payment once you retire when you're eligible for the rest of your life, and then 25% from spouse, or 50-50 or whatever. So on that asset valuation, when we do divorce, we're looking at fair market value now, not what it was 20 years ago. There's going to be experts that may come in to figure out how to divide a retirement account, if that's going to be divided. And the plan administrator could even set up a separate account for spouse. So I work a job here, I have a 403B, a 457, and we have what's called a 401A, which is a type of pension plan. If, let's say, I'm married, and for the last 5 years, I've been contributing to those plans in whatever amounts. The court could view it as, so only the 5 years where you were married would count, and we'll figure out a way to say, okay, you contributed this much over those 5 years, this was the growth over those years, and we'll just consider that when making this separate or multiple separate accounts for spouse. Child custody, the primary thing we're looking at, if there are children, is what's in the best interest of the child. It may not necessarily be where the child wants to go. Maybe kid has more fun with dad because dad lets him stay up all night and eat lots of sugary things. But mom's the better caregiver and dad lives in a deficiency. So we're looking at where will the child have the best chance of success, be loved, be able to continue going to the same school. There's a lot of factors that go into what is the best interest of the child, but that's the primary consideration. If there's been any sort of abuse or addiction issues, one, the dad is on drugs, is in rehab, whatever, that's not going to be looked at as a safe place for the child to be raised. And with child custody, those arrangements can be changed later, just like the child support payments. If we're making child support payments, we can have those looked at again if financial circumstances change. So if I'm paying child support and I get a huge raise, ex-spouse could say, hey, he should pay more because if we were still together, if we were raising the child, more dollars would be able to go to the child. Or maybe I lose my job and I go to the court and say, hey, I can't afford this much. It's not going to allow me to keep a roof over my own head. With that child support, there's also the idea of where is the child spending the bulk of their time. If it's a 50-50 split, as far as how much time the child spends with each parent, maybe we're not paying child support at all. We've also talked about garnishing wages, and if I'm not making the child support payments that I'm supposed to, spouse can go to the state of Alabama, where I'm a resident, and file with the state that here's the court documents, here's what Rich is supposed to be paying, and the government will automatically deduct those dollars from my paycheck before I even receive it, and then direct deposit it into ex-spouse's account. There's no follow-up as far as how those dollars are spent. She could go buy shoes, gumballs, whatever, and buy nothing for the child. The courts just look at it as this is the child support that's supposed to be paid, that's what's going to be paid. With the idea of garnishment, it's a good idea to do this for your clients anyway, because somebody could forget to write a check, you could be traveling and not receive the check. Different things can happen where maybe you don't receive it. This also allows you to have a record of here's the payments that have been made. So even with a amicable divorce, everybody's happy with this is what we're doing, this is, child support is fair, you still want to file with the state to have those wages garnished so that it goes directly to your account and you're never missing them, and you don't have to worry about any of those types of things happening. Alimony, we had different ways we could do that. Temporary, we haven't even divorced yet. We've just started the process. We have our attorneys. Current spouse is going to say, hey, I am not working, I can't afford to pay the attorney, I can't do these other things, and the attorney's going to, yes, we're going to file for that immediately. So I could potentially have to start paying alimony, this temporary alimony, prior to the divorce actually happening. So the temporary would end upon the date of divorce, and then we would look at the rehabilitative, which is allowing the person to be in a position to take care of themselves. So maybe they need some time to get on their feet, to find a job, to